Yeah. Yeah. If there's any, there's not.
He's fine. He's fine. He filed.
They don't go in. They don't.
I'm not.
All right. In 24 CR 2449, you were J.W. Marshall, so present with your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? Yes, sir. You, he's filed a bunch of motions on your behalf.
So
And okay, these things that you're filing, the court doesn't accept that. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You've got to either trust your lawyer, you run this by him, then he'll do what needs to be done. But this is not, or not things I'm going to consider because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time.
yes, sir.
He's been assigned. I don't know if, did you hire him?
No, I was.
Okay, you appointed, and okay, you want to represent yourself? Anytime you want to do that, let me know, and that would be a bad choice.
Yes.
It's always been a bad decision, but some people are insistent, and it never works out well for the defendant. But that's been our experience in this room with 18 and a half years and 600 jury trials. We can figure out what's the right way and what's the wrong way. We've seen it so many times. But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, if you're going to be doing it, he's gone. See you. He's a wise man and he's a good lawyer. You got to trust, run it by him. He knows how to do it and what is the best way to represent a defendant. Okay.
Yes.
All right.
Your Honor, if I may, one of
Yes.
the motions that he did file was for a possible bond reduction. I did file an amended motion that I signed on for. The basis, if I may address the
Yes, sir.
court briefly,
Yes,
is that prior to the charge of murder being filed against him, he was out on bond. There are other cases in his file that he was taking care of, and he was on bond. He was compliant with all the rules and regulations, showing up to court, abiding by the rules and conditions. When this new offense came, then they, of course, put a new bond, raised the bond on the murder charge. And he's been in custody since then. He's asking for consideration, possibly reducing the bond down.
Okay, this in summary states the bond is presently at $1 million and you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is on why this was done this way, but does the state have anything to add here?
Yes, Your Honor. The state obviously would object to any kind of bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. At least 2 of those are in sequence. Also, the nature of this crime, it's alleged that both the defendant and Jamal McCain, another the co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down and shooting him multiple times, both of the individuals doing that.
Anything you want to add, sir? You need to go?
No, sir. Heard that counsel.
Okay. All right. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed your criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime unless it's multiple murder. Number two, you according to this indictment, have at least 4 prior felony convictions that dating back 24 years. And not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is number one, a serious felony of murder, a most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your rich criminal history. So we're going to set this for trial.
We ask that it be said as soon as possible.
All right, y'all, what do y'all need to do to get ready? Because I'm going to try to accelerate this, please.
Your Honor, the won't take much. I think the co-defendant is currently set for
Don't-
October. So
Anything can happen in a case.
I think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. We got everything ready. Mr. Marshall was arrested after this, after we received some
guys.
additional information.
Lacey, I need this set right after the co-defendant's case.
Yes, sir.
Okay, we'll get to, get it, please
Yeah,
note
I've
it.
got
And
the file real quick and then
All
I'll
right.
get them a date.
anything else on this?
No, Your Honor,
Nope.
we'll be
Thank
excused
you.
for that.
That is all. Yes.
Maybe look at it again if we're not ready.
Yes, sir. 25 CR 111 is called the State of Texas versus Harlem Dreamist Briggs. That's your name, sir? And you were here with Miss Minaldi and the state's attorney. This is an initial appearance. As you know, you were charged with the state jail felony of burglary of a building, which carries with it up to 2 years in the state jail. Today, what do we do?
Judge, I'm still waiting on my tape request to be fulfilled.
What do you want to do?
I need 4 weeks, Judge.
You got it? Okay. We're resetting these for 4 weeks, and Jasmine,
It's not-
and this one is as well. Uh, 25 CR 363 is now called Jasmine Young. Is that you, ma'am?
Yes.
Present with your attorney, and it's Ms. Minaldi who is going to represent you. This is a 3rd-degree felony of tampering or fabricating with physical evidence, which carries with it up to 10 years in prison if convicted today.
I need 4 weeks, Judge, for the media.
That's just kind of like you're stuck in that 4 weeks.
Yeah.
4 weeks. 4 weeks.
Happy to try.
Oh, we'll do an announcement in 4 weeks.
Yeah.
Good. Okay.
Thank
Thank
you.
you. Look, the state will be so kind to help. Terrible thing. Choices. They had choices. Bad consequences. 23 CR 229 is called the State of Texas versus Cedric Font. No, that's you.
Yes, sir.
Present with your attorney, Mr. Burbank, and the state's attorney. There's a motion to modify defendant's bond conditions filed
Your Honor.
April 4th. And
Did you get the memo?
okay, first of all, let's look at something else. This is an indictment that was handed up over 2 years ago. Where are we on this?
We're
Where
just
are we
waiting for
on?
trial, Judge.
Ready for trial, Judge.
Okay, we're ready for trial?
Yeah.
All right. Okay.
Instead of altering the bond conditions, why don't we just set trial
Well,
quickly?
that's what you want. We'll set it for trial. Okay, it's set for trial as soon as we can get to it, okay? Then you've got a motion to modify, he's filed this on April 4th,
Yes, Your Honor.
and it states the defendant was released on bond with conditions he wears a GPS ankle monitor, remaining under home confinement and refrain from operating a motor vehicle, requesting the court to modify that provision that he must remain on GPS ankle monitor. In addition, defendant is requesting that home confinement be lifted as well. Okay, so what bond conditions do y'all want?
It's
If,
basically.
if that pretty much wipes it all out,
What we'd like is to be released from home confinement. He's unable to work. He lives with his mom.
okay, wait, I generally allow.
Well, you didn't.
Work. Is there any reason that he can't be allowed to go directly to and from a workplace?
He's in the flea.
Any objection to that? Yeah. That's what I normally do. I allow that.
Yes,
As
sir.
long as it's informing the people who are monitoring him, they know where he's going. And he can go to and from to get food and necessity, to and from church, to and from medical care. Those are exceptions in every case. Otherwise, I'll be held responsible for somebody dying of starvation in their house. I don't want that. I know. He can
But he
do a
goes
couple
with-
of days.
So mom
but-
takes care of him. He's in the flea market. He buys and sells flea market, so like Winnie, he doesn't need to go to Houston. He buys and sells for people. He can tell them where he's going prior. They're usually on weekends and days, so he'll have prior notice. And if that's okay, then I will have him notify the GPS people. And tell them that this is where we're going. But he's living at home. He's been at home. Mom's there to supervise.
So you got someone to drive him?
Yeah, his mom.
Yeah, he can't operate a motor vehicle.
He's not driving.
What
He's not
state say? Any objection to that? I normally
I know you normally do,
allow
Judge. and
to and from the most direct route possible, as long as we get a heads up.
I just
But
want to make
it's not a
sure.
vacation. You're not going on a vacation. You're not
As long as,
partying. This is,
long as we know why he's where he's at, Judge, you always allow that. We do have trial set for September 8th right now.
okay. Well, I will grant the motion for purposes. Just, he's going to wear a GPS monitor.
Yes, sir.
You're going to remain in home confinement. You're going to refrain from operating a motor vehicle. The exceptions to the remain under home confinement is you can be allowed as long as you pre-notify the monitoring official
Yes, sir.
that you're where you're going for work purposes in the most direct route to and from. You can't drive a car, somebody else is going to operate it. You can't go to and from food if you need food to go to buy food. To and from hospital care if necessary, and to and from church.
Right.
That's it.
Yes, sir.
And me.
And to and from legal counseling. Again, all in the most direct route possible. We've had people who are taking wide berths and we know what's going on and those lose their privilege.
Yes, we'll do. Yes, sir.
He's complied with all the rules and regulations.
I know that was up to now. Tomorrow is a new day. I'm worried about making sure that this is followed until we can complete this case disposition.
Maybe excuse.
Yes. Anything else? Tom?
Yes.
You want the Ford that's working on the road? He's working on the road.
He has a good job,
Good.
Judge down in Sabine Pass.
How much you making an hour there, buddy?
2750.
27.50. That's a fortune to most people. That's over $50,000. Good for you. Don't lose it by, acting foolishly. What are we gonna do today? It's an announcement.
Announcement,
Yeah,
I just asked for a short recess, maybe 2-3 weeks, and
3 weeks, you got it.
there wasn't a bond condition.
On this one? No, it says,
It's on my calendar, they might have mixed it up with something.
no, it says, announcement, and it says, I don't see anything. It says defendant on bond. That's all it says, but that's what it says in every case, that we're on bond. There's no, yeah, here, you wanna look at that?
It's nothing there.
Yeah, ain't nothing on.
It wasn't a modification on us. I thought that he had done something wrong on bond.
Well, that's the negative aspect you want to take, yeah.
I'm going to work at home.
Sir?
I said, I'm going straight to work at home.
I'm sorry, I can't hear
He
you.
said he
I've been going straight to work at home.
go straight to work.
Good.
Not staying out the.
Does he have a GPS device or something?
No,
Yeah, I don't think did I order? I don't think I even ordered that.
he's been to court before.
Good, that's the least amount
Go back to work.
of harm's way. But we got to